The Supreme Court ruled Thursday the Sackler family that owned Purdue Pharma and marketed the opioid pain reliever OxyContin is not immune from lawsuits, and that the deal it made with the bankruptcy court to avoid liability is improper. The 5-4 decision was ideologically mixed. The opinion was written by Justice Gorsuch, who was joined by Justices Thomas, Alito, Barrett, and Jackson. The dissenting opinion was written by Justice Kavanaugh and joined by Chief Justice John Roberts and Justices Sotomayor and Kagan. Between 1996 and 2019, Purdue made $34 billion in revenue, mostly from the sale of OxyContin. That gave the Sackler family an estimated net worth of $14 billion. In 2007, a Purdue affiliate pleaded guilty to a federal felony for misbranding OxyContin as less addictive and less subject to abuse than other pain medications. Thousands of lawsuits followed, so the Sacklers began taking $11 billion out of the company, thinking the lawsuits would eventually impact them directly. During bankruptcy proceedings with Purdue, the family proposed to return $4.3 billion to the company in exchange for a judicial order releasing them from all opioid-related claims. But the Supreme Court just ruled that can't happen. Justice Gorsuch wrote in the majority opinion, "The code generally reserves discharge for a debtor who places substantially all of their assets on the table, and ordinarily, it does not include claims based on fraud or those alleging willful and malicious injury. The Sackler discharge defies these limitations. The Sacklers have not filed for bankruptcy, nor have they placed virtually all their assets on the table for distribution to creditors. Yet they seek an order discharging a broad sweep of present and future claims against them, including ones for fraud and willful injury." Gorsuch also wrote that the decision is a, quote, narrow one. He explained, nothing in the opinion should be construed to call into question consensual third-party releases offered in connection with a bankruptcy reorganization plan. Nor does the court express a view on what qualifies as a consensual release. But there's concern this decision could negatively impact what opioid victims ultimately receive as compensation. Justice Kavanaugh wrote in the dissent, "Today's decision is wrong on the law and devastating for more than 100,000 opioid victims and their families. The court's decision rewrites the text of the U.S. Bankruptcy Code and restricts the long-established authority of bankruptcy courts to fashion fair and equitable relief for mass tort victims." It's unclear exactly what happens next, but the bankruptcy deal will have to be renegotiated. Some victims' families want the Sacklers to face criminal charges. At the Supreme Court, Ray Bogan, Straight Arrow News.